Hey everyone, thank you for joining us today and welcome to our webinar, PREA, the Prison Rape Elimination Act 101, Serving Victims, Survivors in Custody. We're going to get started. My name is Sophia Berg. I'm a fellow here at MNCASA, and I'm really excited to be looking at this topic with you all today. Let's see here. So before we get going, I'm just going to touch on some webinar logistics. We have all lines muted, so please share any questions you have in the chat box. We have Ashley here monitoring it, and we'll either address your questions as we go or get to them at the end of the webinar. But please, when you have questions, just chat them in regardless of where we are in the webinar. And the webinar is being recorded too, and then the recording along with a PDF of the slides and a survey, so you can tell us what you liked or did not like and what could be improved about the webinar. And then to the links to some resources I'll reference at the end. All of that will be sent out in an email to everyone registered on Monday. So we're going to get started by going over what we're hoping to accomplish in the webinar today. By the end, we're hoping everyone will be able to explain the role of community-based advocacy agencies under PREA, be able to list the reporting options available for victims, survivors, and incarceration under PREA, and describe what the general facility response should be following an inmate report of sexual violence or harassment being made. And then we're going to also talk about those advocacy skills that are really important to bring into services for victim survivors in detention and incarceration. Again, I just want to mention that this webinar is really introductory, just meant to provide folks with a little more familiarity about PREA and PREA work and serving victim survivors in incarceration. So please don't hesitate to send in questions if you have any at any point. We know victim survivors in incarceration are both really vulnerable and profoundly underserved. In addition to the very large number of inmates who experience sexual violence prior to their incarceration, it's estimated that about 200,000 people experience sexual violence in facilities in incarceration and detention every year in the United States. As service providers, we know how crucial support and services are for the well-being of survivors and how that's crucial and important regardless of where they live and regardless of where they go to sleep at night. So we'll be talking a bit more about PREA today, just because the standards have served as a really important step in addressing the sexual violence that occurs in detention, and because it can be a really powerful tool for service providers who are trying to reach incarcerated populations. We'll be going over a lot of information today, so I'm going to briefly outline our agenda here. We'll be starting with a brief history and overview of PREA, zooming in on the standards that are most relevant for community advocacy agencies. We'll also talk a bit about confidentiality and some confidentiality concerns that are important to keep in mind when providing services to incarcerated survivors. Additionally, we'll cover some information that can be really valuable for advocates to provide to incarcerated survivors. Specifically, we'll be looking at the reporting options that are available for inmate survivors under PREA, as well as the process that should occur following a report of sexual violence being made to a facility. Because facility relationships are really crucial for providing these services to inmate survivors, we'll look a bit at the challenges that can come up in those relationships between advocacy agencies and correctional facilities, as well as some things to do or consider when developing, maintaining, or trying to improve those relationships. And lastly, we're going to end by talking about advocacy work within facilities and with folks who are in facilities. So what skills translate really well into that work that advocates already have, and places where, as an advocate, you may need to consider how you're going to adapt your service provision, similar to how advocates adapt their services for a number of populations that they serve in their communities. So PREA has been a long time in the making. In many places, advocates have been providing or trying to provide services to folks in incarceration for many decades. Similarly, individuals and groups have been advocating for the recognition and addressment of sexual violence in settings of detention for decades too. That advocacy culminated in 2003 with the passage of the Prison Rape Elimination Act. That act kicked off the first ever national research on sexual violence in facilities across the United States. And it also began the drafting of the Prison Rape Elimination Standards. And those standards list out the requirements that are placed on facilities. A draft of those standards was published in 2009, and then in 2012, the finalized version was published by the Department of Justice. There were 4 sets of standards that came out. Each one is for different types of facilities. Today's presentation is focused on the set for prisons and jails. So the standard numbers that come up on some of the slides anyway, refer to that set. However, it's good to know that very similar standards exist in both the community confinement set and the juvenile facilities set of standards. Other federal agencies outside of the Department of Justice that hold people in confinement have their own regulations and standards. So for example, the Department of Homeland Security, or DHS, which houses ICE, the Immigration and Customs Enforcement Department, they came out with their own PREA standards in 2014. There's a number of things that function differently as a result. In particular, the investigation process can look very different. We won't be covering those differences in this webinar because we will be focused on the Department of Justice set of standards for prisons and jails. But if you want more information, please don't hesitate to contact us here at MNCASA. And if you have folks in your service area that are held by different federal agencies, that is just a good thing to know that some things may function differently as a result of that. So PREA was purposed with 3 overall goals: to eliminate the sexual violence in corrections and law enforcement facilities, to increase the accountability of those facilities to the individuals they hold and to the public in their communities, and to provide folks in confinement with the same level of care that survivors in the community receive. To do so, each of the sets of PREA standards include a number of requirements that focus on both prevention and detection of sexual violence. So those standards include, for example, screening inmates when they arrive during intake for both their risk of victimization and the risk of abusiveness, and then taking that screening into account when making housing decisions. It also includes requirements such as when facilities update their video monitoring systems, they have to keep in mind how those systems could prevent and detect sexual violence and help the agency keep inmates safe. In addition, there's a number of standards that focus on responding to sexual violence. So that includes requirements on what the investigation process is supposed to look like following a report being made, and requiring trainings for the medical and mental health care practitioners within a facility on sexual violence, so they're better able to understand what that looks like and what they need to do when it comes up. Access to outside community advocacy services was recognized as really important for PREA's goals. 2 standards in particular speak to the role of advocates. One standard required facilities to provide inmates with access to community advocates or outside service providers for emotional support services relating to sexual abuse. That standard is not related to reporting, and that access should be provided to inmates regardless of whether inmate survivors have made a report or even if they want to make a report. These emotional support services should be available to survivors who experience sexual violence outside of the facility, as well as survivors who experience sexual violence inside the facility. The other standard, which is related to reporting, stated that after an inmate has made a report, they should have access to an advocate during the forensic medical exam, any investigatory interviews, as well as for emotional support, information, crisis intervention, and referrals. Importantly, that standard also states that inmates should be provided with access to a forensic medical examination, and that exam should be performed by a sexual assault nurse examiner or a sexual assault forensic examiner whenever possible and when appropriate. And all of this should be provided without any cost placed on the inmate survivor. So I'm going to take a moment here to pause and have folks on the webinar share their experiences with service provision to survivors in custody. I'm going to be putting up a poll in a second here, and if the multiple choice options don't accurately capture your experience, please feel free to chat in your response. So I'm going to just take a minute where I'm going to pause myself here, pull up that poll, and let you all respond. All right, so you should all be able to see the results here. It looks like a large number of folks have provided in-person support and services, as well as over the phone. And I should have noted this before. Sometimes when you're providing support over a crisis line, it is hard to tell whether folks are in a facility. They might not disclose that to you. So it is very possible that advocates have experience providing support and services over the phone to folks who are incarcerated and just don't disclose that information to them. It looks like some folks have also provided hospital accompaniment, and then there's people who also have no service provision experience. So it's great that we have a little bit of diversity there in what experience folks have. Thank you all for sharing. There we go. All right, so as we've talked about, there is a PREA standard that requires facilities to provide inmates with access to support services relating to sexual abuse, and that should be provided in as confidential a manner as possible is the language they use in the standard. Again, that standard isn't related to reporting, and inmates shouldn't have to make a report to access these services. Farther, facilities are required to attempt entering into agreements with community service providers to provide those services. And that attempt to come up with those agreements has to be documented as well, regardless of whether community service providers are able to provide services or not. So that requirement speaks both to the accountability of the standards we're trying to place on facilities to provide these confidential services, particularly from community service providers. It also speaks to the importance they saw in providing community-based advocacy to inmate survivors. Right. So the privileged relationship that sexual assault advocates have here under Minnesota state law, VOCA requirements and VAWA requirements, they all apply the same when serving victim survivors in incarceration and detention, as when they're serving victim survivors in the community. Minnesota facilities ideally should be aiming to provide a similar level of confidential communication between advocates and inmate survivors as they do for communication between, say, people in incarceration and their attorneys. The mandatory reporting laws that affect advocates when serving survivors in the community also operate about the same way when serving survivors in incarceration and detention. And it can be good to note that people in custody of county jails and state prisons in Minnesota are not considered vulnerable adults under Minnesota state law. I know there can be a lot of questions with this, so feel free to type any questions you have in. I'm not an attorney, but I can try my best to help you with those. As advocates who want to provide confidentiality, both for survivors who haven't made the report and for survivors who have made a report, it's important to look at the different modes of communication that are available between inmate survivors and the advocacy agency. We want to make these as safe and confidential as possible. Inmates who report prior sexual victimization have been found to be 20 times more likely than inmates who haven't to report further sexual victimization within a facility. That reflects that similar to in the community, people who are perceived as vulnerable in facilities, perceived as unlikely to be believed and unlikely to make a report, are targeted for sexual violence. And the knowledge that someone has experienced sexual violence before can make them a target for further sexual violence in the future. And as advocates, the last thing we would want is for that folks accessing advocacy services to contribute to the risk of that occurring. So in order to determine the level of confidentiality of a mode of communication, it will be necessary to have conversations with facilities. Facilities will be able to provide information about what is and isn't monitored, how inmates are able to send mail or make phone calls. They'll also be able to work with you to make communication between advocacy agencies and inmate survivors more confidential if possible. In those conversations, it can be really beneficial to inform facilities of the legal confidentiality requirements advocates are held to. So when looking at communication options, we still always want to make sure we keep in mind how the communication is aligned with the advocate and survivor relationship. We'll go into some of these considerations in a little more detail, and I'll talk a bit about the primary modes of communication that often exist between advocates and inmate survivors. With all modes of communication, there often will be a balancing between the facility's concern for security and the advocate's concern for confidentiality. But as always, it's important to inform inmate survivors when and how confidentiality is limited upfront.
Yes. There was just one question
Yeah.
to clarify. Does PREA apply to work release programs as well as standard incarceration?
So work release programs, if they're like staying in a community confinement facility, if that makes sense. So I think often those can be referred to in a number of ways. So then yes, it would. Generally, any confinement facility that holds people and receives federal funding should be held accountable under DOJ PREA. Yes, I hope that answers. If not, please send it in. Yeah.
Okay.
Send in a further question. Right. So mail is commonly used by folks in facilities. It's also commonly monitored by facilities. However, it may be possible to have mail that goes to and from advocacy agencies marked as official, legal, or special mail. Phones also are commonly monitored in facilities. Additionally, inmates may need to pay in order to use them and may only be able to use phones during certain hours of the day. The phones available to inmates might not be in a private space, which can increase the likelihood of inmates being overheard when they're using them. So with all of that in mind, talking with facilities about providing unmonitored free phones located in spaces with a little bit more privacy and that connect directly with advocacy hotlines can be really helpful. However, it's also good to keep in mind that if a phone is designated for usage to an advocacy hotline and that hotline only, inmates seen using it may be outed as survivors. So for that reason, some facilities have designated phones that can be used for multiple purposes. So for example, for attorney communication and advocate communication. The possible downside to that is how busy those phones may be as a result of being used for multiple purposes, and then how easy it is for inmates to access them as a result. Again, it'll be important to communicate with facilities about these concerns and what provisions can be made. As an advocate, it's also just good to know the type of setup inmate survivors are using to call you from. In-person meetings with inmate survivors can be contact or non-contact. Contact meetings mean that the advocate and survivor are usually in the same room. Non-contact meetings means there will be some sort of physical barrier between the advocate and the survivor. Regardless of whether meetings are contact or non-contact, it's important, again, to consider confidentiality. So talking with the facility to determine where you will meet the inmate survivor, how those meetings will be coordinated, who will be able to see you when you're meeting with them. All of that will be really important. Ideally, for contact meetings, you'd be in a room where you can't be overheard and the audio isn't being monitored. It's most likely that for contact meetings, you'd be in a room where there is a window, but with the most ideal situation being that the only people who see through that window are staff who are required to for monitoring for security purposes. Some facilities can have these meetings in a community services or programming office area, and that can be really great because inmates seen going to those meetings could also be going to other programming such as substance abuse programming or to see a caseworker or social worker. Some advocacy agencies also provide group sessions or support groups within facilities. Confidentiality in those settings are of course different. However, some advocacy agencies do still want to avoid outing people who attend, inmates who attend, as survivors of sexual violence. So to do so, sometimes folks will take into consideration how their group is being advertised throughout the facility. They'll take the name and the description and try to make its scope a bit broader outside of sexual violence. So for example, to include all forms of violence, to be about trauma more generally, to have a focus that's more educational or about coping mechanisms, but still including sexual violence focused pretty heavily within the curriculum.
There was one question. How do inmates know that they have rights under PREA? Is PREA required to be posted somewhere?
It is required to be posted somewhere. So they should have posters up. They should be providing them with updates yearly. or a refresher, a check-in on their PREA rights yearly, and they should also be informed of their rights upon intake. Yeah, how that information is provided, how accessible it is for folks who have limited English proficiency or other concerns varies by facility, but ideally they would be getting that information at least at those points. Okay, so moving on from how services can be provided to survivors in incarceration, we'll now be looking a bit at some information that advocates can provide to inmates who are considering making a report or who just want some more information about it. Under PREA, inmates should be provided with a number of reporting mechanisms, and that was done because research has shown that inmates often don't trust, understandably, the staff and the agency that's holding them in confinement. It was also done to increase the accountability of facilities. So first off, inmates should be able to report to any facility staff member, contractor, or volunteer. And all of those folks should be trained about taking a report and what to do once a disclosure is made to them. PREA also requires for agencies to have multiple internal mechanisms through which an inmate can make a report. You'll want to ask your facility what those are because they can vary a bit on what they look like. Third-party reporting was also included under PREA. So that would look like a survivor disclosing knowledge or their experience of sexual violence in a facility to someone in the community, and then that community member being the one to make a report to the facility. Lastly, inmates should be provided with the contact information to an outside agency that they can report to. So an example, this is for juvenile facilities, folks being provided the contact information for Child Protective Services, or for state facilities, inmates being provided the contact information for the state Inspector General Office. Okay, great. So with outside reporting, the purpose was to provide inmates with the option to report to an entity other than the one that has custody over them. Because of that, facilities cannot contract with an answering service to perform the function. Additionally, this shouldn't be conflated with a counseling or crisis hotline. So another example of what this can look like in practice is inmates in a county jail being provided with the city police department phone number. With third-party reporting, members of the community, so this includes friends and family of inmates, can make a report to the facility. The way to make a report must be easy for members of the public to find and use, and it must be taken as seriously as any other report would be, regardless of if a survivor or an abuser is named when the report is made. So another example of this would be a family member calling the facility after receiving a letter describing the sexual harassment an inmate is experiencing. And lastly, facility staff are mandated reporters, as said before, and that includes medical and mental health providers within the facility. So staff must report any knowledge, suspicion, or information about sexual abuse or harassment that occurs in a facility. And that applies regardless of the agency. So if they learned an inmate experienced sexual violence at another facility before coming to their current facility, staff are required to report that as well. So that could look like someone transferring from a county jail to a state prison, and then once in the state prison reporting sexual violence they experienced in the county jail. Additionally, staff are required to report any information, suspicion, or knowledge of retaliation against reporters, staff, or inmates. So for example, that could be someone who witnessed sexual violence but wasn't a survivor. And they also must report so they must report any retaliation against reporters or survivors. And they also must report any staff neglect or violation of responsibility that may have contributed to an incident or retaliation for reporting an incident. Right. And after a report is made, facility staff are required to take certain actions under PREA. This information can be really helpful for a survivor who is considering making a report. The actions facilities are required to take include separating the survivor and the abuser. Abuser is the language used in the PREA Standards, which is why I'll be using it here. They also request that the survivor not take any actions that would damage physical evidence. So that includes asking them not to shower, not to go to the bathroom, etc. The abuser is told not to take any actions that would damage physical evidence as well. And then the facility's coordinated response should then be activated. What that looks like, that response can vary by facility. So it's really helpful to ask facility staff what the response procedure looks like, so you're able to provide inmates with a little more information. So after a report, investigators will interview the survivor, the abuser, and any witnesses. Again, facilities are responsible for ensuring an advocate is available for survivors throughout these interviews. If the report includes criminal behavior, a referral for criminal investigation is made. So for example, the local law enforcement would be contacted. Agencies should be taking protective measures for the survivor and any reporters of the sexual violence. These measures, again, can vary depending on the facility and agency, but they could include housing changes or transfers, removing abusers from contact with the victim, and providing emotional support services for those who fear retaliation, both for reporting or for cooperating with the investigation. And these protection measures should be both for the survivor and again for the person who made the report, if it was someone other than the survivor. So the survivor and/or reporter's conduct and treatment should be monitored for 90 days. How that monitoring occurs can vary again by facility, but its focus should be on preventing and detecting any retaliation made against them for making the reports. Once an investigation is complete, the survivor should be told what the determination of the investigation was or why an investigation did not occur if it didn't take place. If the abuser was a staff member, the survivor should be provided with updates on the staff member. So those updates would include whether the staff member is no longer working in the inmate's unit, whether they're no longer employed, and if they've been charged. Any substantiated allegations that appear criminal, again, are referred for prosecution at that point. Following a report, a survivor should not be placed in segregated housing, which is also known as solitary confinement, without an assessment showing there were no viable alternatives for the survivor's safety. If they are placed in segregated housing, survivors should not be there for more than 30 days without another review taking place, and they should have access to the same programs, privileges, education, and work opportunities that they otherwise would have had to the extent possible. As touched on before, survivors should have access to a forensic medical examination, as well as emergency medical treatment and crisis intervention services, information and access to emergency contraception and STI treatment. This all should be provided without financial costs, regardless of the person's cooperation with the investigation or their naming of an abuser. Again, this information can be really helpful for inmates to receive from advocates if they want it. So we're gonna switch gears now to something that probably everyone is pretty familiar with, relationships with other organizations. And we're gonna start thinking about this just by having everyone share some challenges that are common to relationships with outside organizations more generally, not just looking at facility relationships. So what's coming to mind for folks? Please chat them in. We're gonna use the chat box to think about this a little bit. And again, this is just thinking about challenges with organizational partnerships in general, not with specifically correctional facilities. So I'll give everyone a moment here to chat in their thoughts.
We can just see if folks here, if you're typing in. So what are some common challenges that you have with organizational partners?
Yeah, and please feel free to chat those in. I'm going to continue on with some things that I had thought of. But again, please feel free to elaborate and share with your experiences or other things that I may have missed here. So relationships are often affected by differing philosophies. So for example, that comes up with facilities and advocacy agencies around particularly confidentiality and safety. There are very different approaches to that within each organization. Another challenge commonly is limited funding. PREA did not come with more funding for advocacy agencies, and many of advocacy agencies are just asked to expand their services without expanding the capacity they have to provide those services. Additionally, both advocacy agencies and facilities are commonly affected by high staff turnover, and that can be particularly challenging for maintaining both organizational relationships and good understandings of one another's roles in your partnership.
Yeah, one person mentioned here, I'm not sure if this is specifically answering this question or just kind of shedding light on all of this in general, said that this person did not have experience working with PREA yet, however, has got information that some folks or that people in the corrections facility in their community have never heard of PREA. So just kind of concerned about how inmates are getting that information if even the corrections staff are unaware of PREA.
Yeah, that's very fair. I would be curious a little bit what type of correctional facility that is, because we have heard, particularly with county jails that don't receive federal funding or are of the understanding that they don't receive federal funding. They don't see themselves as being PREA compliant. And like Minnesota, for example, when they submit the information to show that the state is PREA compliant, they only submit the audits for state prisons. So that again can reinforce that understanding that it's only on like state prisons and federal prisons to be PREA compliant, despite the fact that, you know, we have standards written for a wide variety of facility types. You know. So despite all those challenges that can come with organizational partnerships, there are some things that can be really helpful in addressing them. So to start off, it can be really helpful to utilize any community connections that exist. That includes contacts on multidisciplinary teams or contacts on facility staff. Regardless of what contacts are pre-existing, it can be really helpful to build relationships with leadership at the facility. And that can look many different ways, like asking the facility leadership to speak at your staff meeting or even at a community multidisciplinary team meeting about their work and their agency's work too. Relationship building can also include facility tours and trainings across advocacy and correctional staff. In addition to relationship building, facility tours can be really helpful for developing and learning more about what communication options exist between advocates and inmate survivors. And again, to have a better understanding of the setting the folks you're serving live in and the setting they're in when they're contacting you for services. Both in trainings and in conversations, it's really important to talk about the roles of corrections and the roles of advocacy and build a base on those shared goals advocates and corrections have to ensure the well-being of everyone in the facility and our communities. It's also really important just to have those detailed conversations about confidentiality and safety, what that means to everyone at the table and how they are important and function in one another's work. So a great tool for these relationships are memoranda of understandings or other written agreements. Under PREA, facilities are required to attempt entering into those agreements with community service providers. If possible, it's recommended to update these with facilities 6 months after initially creating them, and then revisiting them annually. And part of why that recommendation has been made is because things can look really great on paper, but then after putting them into practice, you realize some things need tweaking. These annual meetings to revisit MOUs or written agreements can also be another avenue for maintaining relationships over time. So revisiting MOUs can be helpful for that. They can also be helpful in regards to improving the confidential communication options that exist, because as you provide services and develop relationships with facilities, you may learn there are other options through which you can communicate with inmate survivors that you didn't know about before. It's also really important to keep documentation of your work with correctional facilities. Every 3 years, facilities are supposed to have a PREA audit in which the auditor is supposed to reach out to community-based advocacy agencies or the service provider in the community to see how that relationship has been going, what services they're providing, and how they're providing those services. In practice, PREA auditors don't always reach out to community-based advocacy agencies, despite the fact that they're supposed to, regardless of whether they're working with the facility or they haven't been able to form a partnership with the facility. So if you want to talk with a PREA auditor about how your relationship has been going, you can also look and see when your facility's audit is coming up and then contact the auditor of your own volition. But keeping documentation in general is really good for when those auditors contact you and also for your own records as well. So when developing these relationships and agreements, you can include discussion over a lot of what we talked about earlier and have details written into MOUs and agreements about how confidential services will be provided. So that can include having private, unmonitored, and free phone lines to advocacy agencies within the facility, agreeing that there will be blank release of information forms available in the facility, that there's going to be ongoing regular trainings across both staffs, and agreements on what meetings with survivors will look like. So again, if they're contact one-on-one in-person meetings, having them in rooms that cannot be overheard or where you won't be seen more than necessary, and possibly having them in a community services office area to maintain some more confidentiality. When working with facilities, you can also offer up your expertise as a resource for them outside of providing direct services. So the PREA standards, as we talked about earlier from the question, do require facilities to provide educational materials to inmates about their rights to not experience sexual violence or retaliation for reporting sexual violence, and how the agency is supposed to respond when sexual violence is reported. So you can help with developing these materials or even just make recommendations to the facility about what they include or don't include in those materials. So that can include suggesting that they advertise or list the community advocacy resources that exist, that they clearly state the confidentiality of communication options that exist, and do so in a way that's accessible for folks to understand what that means. Help them avoid language that can victim blame and make survivors feel like they're responsible for preventing the sexual violence targeted at them. And then also by recommending that facilities clearly distinguish between counseling and support hotlines and reporting hotlines and what those mean, because again, that can get confusing really quickly for folks who aren't familiar with how those systems work. It can also be really good to have conversations with facility staff about other aspects of service provision to survivors as well. So including survivors' access to forensic medical examinations. While advocates are very familiar with being victim-centered and trauma-informed in their work, those ideas are often very new or unfamiliar for corrections facilities and their staff. So with forensic medical exams, talking through how survivors are brought to the exam and any concerns that you may have about that process. So for example, if you find out that survivors are being strip searched on their way to and from the exam. And then also talking about privacy during the exam itself. So often handcuffs will remain on the survivor throughout the exam, and a correctional officer will be constantly monitoring the exam while it's happening. But you can talk with corrections, ideally ahead of an exam happening, about how their concern for security can be balanced with the advocate's concern for the survivor's privacy. In practice, that balance could look like the officer visually monitoring during parts of the exam where the nurse is talking with the survivor, but not being able to hear the audio of the conversation. So for example, the correctional officer being outside of the room but looking in through the window, and then being in the room itself but behind a curtain when the exam is happening. So then they can they can monitor with audio but are not able to visually see what's happening during that part of the exam. So those examples touch on how the skills and knowledge of advocates can be really important and needed for the services provided to incarcerated survivors. Because you all are the experts, it'd be great for folks to briefly share some other examples that are coming to mind too about advocacy skills and knowledge that are really important to bring into service provision for incarcerated survivors. So I'll pause again, so hope folks can hopefully chat in what's coming to mind to them about the skills advocates have that are really important to bring into service provision for incarcerated survivors. And just the work that that service providers do that's really beneficial for folks in incarceration who experience sexual violence. So I'll give you all a minute here. All right, so folks, please still feel free to chat in. It's all right to be a quiet group, but I'd love to hear from you all. Some of what I had thrown up here, and this list, of course, is not exhaustive, but it includes that advocates are there to be a person that believes them and can be there to hear them. And then having that understanding of sexual violence and the impact it has can be really, really powerful for the service provision. And this can feel very basic, but simply recognizing that people in incarceration are people with names and feelings can be really powerful, especially considering that they're often not treated that way due to the setting they're in of incarceration or detention. And on top of that, being able to provide what advocates do. So being able to provide support, resources, information, and referrals if they want it. And again, recognizing them as the expert of their experience. This all can be really powerful to provide for folks who are constantly being told where they have to be, what they have to do, when, and how they should be doing it.
We did have somebody type in.
Yay, okay.
Being familiar with services that clients can receive while in facilities, many people may not be aware of what resources they have, such as mental health services.
Yes, yeah, that's really big.
Mm-hmm.
Thank you for chatting in. And other folks, please feel free to chat in too, and we'll make sure to share your responses. So with all of that in mind about what advocates can provide and how powerful and important that is, there are very real constraints that advocates do need to adapt to when providing services to folks in incarceration. Inmate survivors aren't able to choose where they are, as we touched on and folks know. They aren't able to do things like go for a walk outside when they want to or when they need to for coping. They aren't even able to turn lights on and off when they want to. And that affects safety planning. But again, survivors are the expert of what will make them safe, and advocates are able to advocate for certain things on behalf of survivors, like housing transfers. They're also able to make plans with survivors, like agree that if they don't hear from them in 3 weeks, that they'll reach out to the survivor's caseworker, of course, if the survivor wants and agrees to that. Also talking with the survivor about what people around them they trust and feel safe, and whether they want to incorporate them into their safety plan as well. However, there are I said, a lot of constraints. And we've touched on this already with forensic medical exams. But survivor inmates may not be able to eat or shower immediately after the exam like other survivors, and differences like that are important to keep in mind for when you're providing services. When talking with survivors about different coping mechanisms, it's also important to be cognizant of these constraints that exist. So talking about different options that are accessible to them, like guided imagery, breathing techniques, and possibly journaling is another example if the facility will allow them to have a journal. Because inmate survivors aren't free to go to different resources in the community in the same way other survivors are, you may also have to do some research and think creatively about what resources are accessible to inmates. And as the folks who commented in said, find out what programming exists within the facility that may be helpful for them too. Okay, so we've covered a lot. So I'm going to go back to our objectives now that we're winding up to the end here. By going over the PREA standards on community advocacy, talking about how advocates can provide confidential services through different modes of communication, and how advocacy agencies can work with facilities to improve the services provided to inmate survivors, hopefully everyone can better explain the role of community advocacy agencies under PREA and provide descriptions of what that role looks like in practice. To cover information that survivors may want about reporting options and what response procedures facilities are required to have after a report is made. We talked about those responses that are required under PREA and the reporting options that are required under PREA. Lastly, we also talked about the skills advocates have that are really important for service provision to survivors in incarceration, and how advocates can adapt their service provision to the constraints that come with incarceration. So again, this was a very introductory webinar. So I'm going to end by making a plug for some other really great resources that exist. Just Detention International has been a huge part of even getting PREA into existence and providing support to service providers after it has gone into effect now. And they are continually advocating for survivors in incarceration. So their website has a lot of resources, both for survivors of sexual violence and incarceration, and also for service providers. The National PREA Resource Center, which I also have up in the corner there, has a lot of great resources around PREA, of course, on their website, but they are generally geared for an audience of corrections agencies and facilities. So that's also good to keep in mind, that as a service provider, a lot of their resources may not be geared for you as their audience. One Just Detention International, or JDI's, resources is called Hope Behind Bars. It's designed as a guide for advocates who are beginning to work or are working with survivors in custody. It contains a lot of really great information, and it's already used by some folks here in the state of Minnesota, and they highly recommend it. Another resource designed for advocates was created by the Colorado Coalition Against Sexual Assault, and it provides another comprehensive overview of advocacy services for inmate survivors. Both the Hope Behind Bars and the Colorado Coalition's resource are similar in structure, but they have some different pieces of information that the other doesn't have. So I recommend both of them. And then the next resource I have up here is a Just Detention International fact sheet. It's a little older, from 2013, but it still provides a really good overview of PREA for service providers. Just Detention and the PREA Resource Center also co-created this fact sheet, Untangling the PREA Standards, and that breaks down the different reporting options that we talked about today that exist under PREA, and it provides examples of how those different reporting options can work together with the confidential emotional support services that inmate survivors are supposed to have access to under PREA. It also gives examples of how different reporting options works really well for different survivors and different scenarios they're in. So it just helps you think a little bit more about what those look like and why the different reporting options are all important to have. All of these resources, along with others, can be found on Coalition Manager under the PREA section. They're all hyperlinked there. And of course, MNCASA is also always around to help. So I'd love to take a few minutes now just to hear any questions folks may have. So please feel free to chat those in the chat box. and hopefully I'll be able to provide some answers. I'm also just going to remind folks that we'll be sending out a recording of the webinar on Monday, along with these resources that are up here and their hyperlinks. So you'll be able to just click on them and go straight there, as well as the survey. So again, please tell us how we can improve, what you liked, what you don't like, and what you want to learn more about in the future. That would be really helpful. And I'm going to throw my contact information up there for a minute and then go back to the resources. So if folks want to write those down, they can. But I will just hang on for a bit here and see if folks have any questions. Again, please feel free to chat them in. And thank you all for being here with us today.
So there is a question. How do we provide advocacy for a client who is in a facility that's not PREA compliant? Example, they want to make a free call but are unable to.
Yeah, that's a good question. You're in a tough spot. And honestly, that is something where you try to work with facilities and develop those relationships and get them to understand why advocacy services are really important. There are other benefits. So for facilities that you can talk to them about, so even if they're not PREA compliant, they are probably, I would imagine, required to have an investigation after a report is made. And people who make reports are often more comfortable and more cooperative if they have advocacy services there to help them. They're also more likely to make reports about the violence they're experiencing in those facilities if they see the facility cares for them by providing them with access to advocacy services. So facilities often will emphasize that they want to know everything because everything that's happening in their facilities so they can ensure there's security and safety. And we know that folks are more likely to report violence they're experiencing if they have access to advocacy services. So you can try to make those arguments that even if they're not PREA compliant, it's in their best interest to have advocacy services there to maintain the security and safety and well-being of everyone in their facility. But yeah, that is really hard. You also can do a little more digging. Please also feel free to reach out to us and see maybe they are supposed to be PREA compliant and they're just not realizing that. So that's another thing. But yeah.
And then there's a follow-up question to that too. Is it a violation of their civil rights?
I would think so. Yeah, I mean, yeah. And I think Just Detention International on their website has a lot of really great stuff written up on this. Yeah, it is. I mean, PREA went into place because facilities weren't recognizing it as a violation of their civil rights, and it clearly is, but yeah.
Just Detention International has resources specifically around the civil rights piece, is what you're saying?
Oh, maybe I shouldn't have said that. They have information about how it's a violation of human rights, for sure, yeah. And I would imagine probably have more. I'm sorry, I'm not very qualified to answer this question probably, but Just Detention International does have a lot of really great resources on why this is important and why facilities should be implementing and providing access to advocacy resources.
Sure.
Yeah, I can find more information and we can send that out too in the email on Monday. We'll do that for you. All right, folks, you should feel free to log off if you don't have any questions, but please feel free to still chat questions in. We'll be here for a couple more minutes anyway to answer those. And then again, feel free to contact me or call any of us here at MNCASA, and we'll do our best to answer your questions. And like I said, we'll send out some more resources on Monday. And then there's those resources and a number of other ones on PREA on Coalition Manager if you want to learn more. Thank you all. All right, folks, so we're officially going to end the webinar now, but please always feel free to reach out and send us more questions. And we will be sending these resources out again, like I said, on Monday, and I'll send some more resources and information that hopefully better addresses those questions there. But thank you all.